This reading gonna come from performance contract law, performance in law, act of doing that which is required by a contract. The effect of successful performance is to discharge the person bound to do the act from any future contractual liability. Each party to a contract is bound to perform promises according to the stipulated terms. In case of any controversy as to the meaning of a promise, the court have usually decided that a person must perform it as the other party reasonably understood it to be. Thus, a preference for the rights of the one who is to receive the benefit of the promise is established. Attempts to establish hard and fast rules about reasonable interpretations of promises are now discouraged, although at one time a person would be held to the literal meaning of a contract provisions stated a promise. The requirement now is to perform the true meaning and intent of the contract, which may not respond with the fine print. Consideration in contract law: an inducement given to enter into a contract that is sufficient to render the promise enforceable in the courts. The technical requirement is either a deterrent incurred by the person making the promise or a benefit received by the other person. Thus, the person seeking to enforce the promise must have paid or bound himself to pay money, parted with goods, spent time and labor, or foregoing some profit or legal right. In a contract for the sale of goods, the money paid is the consideration for the vendor, and the property sold is the consideration for the purchaser. This definition, however, leaves unanswered the question of what is sufficient consideration. During certain periods of history, nominal consideration was held to be sufficient. Even a cent or a peppercorn, generally in court, came to require that the consideration be valuable, although not necessarily equal in value to what is received. The courts have had to decide specifically whether acts of forbearance on the faith of a promise, the giving of a counter-promise, money payments, pre-existing duties to the promisor, pre-existing duties to third parties, moral obligations, love and affection, surrender of another legal claim, or performance of a legal duty were sufficient, and the answer has varied considerably over time. The doctrine that a consideration is necessary if a contract is to be enforceable has a number of functions in the law of contracts. In addition to providing evidence that a contract exists, consideration also has to be cautionary function of guarding the promisor against ill-considered action, the deterrent function of discouraging transactions of questionable utility, and a channeling function of enabling interested persons to distinguish particular types of transactions. Although the doctrine of consideration is unique to common law, these functions are also performed in other modern systems of law. Force majeure. In French, that means superior force. In commercial and international law, an extraordinary or unforeseen event whose occurrence would free the parties in an agreement from certain obligations to one another, force majeure. Incidents typically include wars, natural disasters, i.e. earthquakes, terrorist attack, epidemics, and civil unrest, such as riots. The concept of force majeure originated in French civil law as part of the Napoleonic Code and has been incorporated into the common law and civil law in many countries. A force majeure clause is commonly written into commercial contracts and international treaties. Force majeure and commercial law. A force majeure clause of a contract is used to protect the parties from certain types of liabilities or losses. Force majeure does not encompass events that are predictable, preventable, or controllable, or that result from the negligence or malfeasance of one or more parties. Natural events that would trigger a force majeure clause are often referred to as acts of God. The force majeure clause of a contract will typically specify what type of event would relieve the parties of their contractual obligations. Such event typically must be extremely unusual. An example is the COVID pandemic. Such sweeping global infections have occurred only rarely in modern history. Unforeseen or unanticipated by one or more parties and out of all parties' reasonable control, the spread of the COVID was more rapid than anyone anticipated. World government responses to the pandemic were beyond the control of business enterprises, such that the obligations agreed to by one or more parties of the contract become impracticable, illegal, and impossible. A pandemic may shut down a supplier's business, stopping all of its deliveries to clients. When a force majeure clause is triggered, any party affected by the event must notify the other party or parties to the contract. The affected party will describe the start date and circumstances of the incident and cite the specific section in the contract that allows them to declare a force majeure incident. They must then estimate how long the force majeure may be in effect and provide the other party or parties with regular updates. However, even under force majeure conditions, the parties may not always be completely relieved of their obligations. For example, if a sudden flood forced a supplier to miss the scheduled delivery, the company would invoke a force majeure clause, but when the flood water receded, the supplier would be expected to deliver the promised goods. Likewise, if a partial delivery of goods was made before the force majeure incident, the receiver would be obligated to pay the supplier for those goods. Contracts and treaties between countries also generally include force majeure clauses. Several international legal organizations, such as the International Chamber of Commerce and the United Nations Convention on Contracts, or the International Sales of Goods, and the Vienna Convention on Laws of Treaties have offered similar definitions of the type of events that would trigger a force majeure clause. As in common and civil law, the event must be unforeseen and uncontrollable to make it impossible for one or more parties to fulfill their contractual or treaty obligations. One prominent example of a failed invocation of force majeure under international law occurred in February 2023 when a high-altitude balloon that had been launched from China was seen in the air above the northern United States. The balloon's presence within the borders of the United States ostensibly violated both United States and international law. The Chinese government asserted that the balloon was a civilian meteorological airship that had been driven off course by errant wind, which made its entry into United States territory a force majeure accident. The United States disputed this claim, pointing out that China had acknowledged of their prevailing winds and therefore should have known where the balloon was likely to go. Also, the balloon changed course several times while over United States territory in a manner that indicated that it was under some type of remote control. Finally, China did nothing to avoid or remove the problem or to warn the United States. Accordingly, the United States claimed that the balloon was engaged in espionage and shot it down. The military forces of most modern countries may also claim a force majeure defense in certain cases to avoid provoking international conflicts. For example, the United States military aircraft damaged by a mid-air collision or by a lightning strike could declare a force majeure event. The requesting emergency landing in a country such as China, the granting of permission under this defense could help to prevent increased tension between the two countries. Bond. In law, a formal written agreement by which a person undertakes to perform a certain act, e.g., appearing in court or fulfilling the obligation of a contract. Failure to perform the act obligates the person to pay a sum of money or to forfeit money on deposit. A bond is a incentive to fulfill an obligation. It also provides reassurance that compensation is available if the duty is not fulfilled. A surety usually is involved, and the bond makes the surety responsible for the consequences of the obligated person's behavior. Agency in law. The relationship that exists when one person or party, the principal, engages another, the agent, to act for him, e.g., to do his work, to sell his goods, to manage his business. The law of agency thus governs the legal relationship in which the agent deals with a third party on behalf of the principal. The competent agent is legally capable of acting for this principal, vice versa the third party. Hence, the process of concluding a contract through an agent involves a twofold relationship. On the other hand, the law of agency is concerned with the external business relationship of an economic unit and with the power of the various representatives to affect the legal position of the principal. On the other hand, it rules the internal relationship between principal and agent as well, thereby imposing certain duties on the representative: diligence, accounting, good faith, etc. The two relationships need not be in full conformity. Thus, an agent's effective power in dealing with outsiders may extend to transactions that he is under a duty to his principal not to undertake, leading to a situation characterized as apparent authority. Agency is recognized in all modern legal systems as an indispensable part of the existing social order. It fulfills the most diverse functions in both public and private law. In particular, it assists in organizing the division of labor in the national and international economy by making it possible for a principal greatly to extend his individual sphere of activity by having one or more persons act for him. In addition to the individual principal, the principal may be composed of a group of persons carrying on a trade or business by way of a partnership, a registered company, or another kind of corporate entity. The need for legal representation in some form has therefore increased as business units have come to involve transactions conducted at a distance through the use of factors or commercial agents, or have grown in size, as in the case of the firm, the house, and the corporation. Continental law additionally allows the use of legal representatives such as the father, mother, guardian, or curator to enable minors, insane persons, or other legally incapacitated persons to act. Although a similar category of authority by law is not known in common law, powers based on family relationships to scarce and appear in only a few cases. And this reading was, let's see. This reading came from Britannica.com about performance and just about contract law.